Welcome everybody to another Quantacast Professional Series. My name's Tim McKinley. I'm the Chief Operating Officer here at Quanta. This is episode 4 in our series. On my right, as I always have, Stacey Jones. Welcome, Stacey.
Thanks, Tim.
And on my left, I have a very special guest with us today to discuss a private advisory, wills and estates, which is quite an interesting topic for our investor group, Stacey. I'd like to welcome Paige Edwards. Welcome, Paige.
Thank you, Tim.
Paige, I'll run through just quickly a little bit of your background. Paige began practicing in 2012 in the area of private advisory and estates. Spent most of your time, Paige, with McCullough Robinson in senior associate role and also special counsel. Recently joining AJ & Co lawyers, who we do some business with ourselves as a partner. So congratulations on that. And again, specialising in private advisory, wills and estates. Hopefully I got that right. Just on AJ & Co. AJ & Co are based in Brisbane CBD. They were founded by Andrew Johnson. They specialise in everything from corporate real estate, Stacey knows this, corporate advisory, litigation, employment law, and of course your area of expertise, Paige. So let's open up the conversation, and I'll start with you, Paige, because we know that this is discussed amongst, as I said, our investors regularly. Estate planning can be a sensitive yet and crucial topic for everybody, I guess, especially for those who've got some wealth tied up in various assets or investments. Can you let us know why you think it's right to get your matters sorted as early as possible to make sure you've got a smooth transition later in life?
Yeah, so there's a lot of reasons why a complete estate plan is a really important thing for people. The first and most critical one for plenty of our clients is that it is one of the best things that you can do for your family or your friends or the people that are going to benefit from your estate. Obviously, if something happens to you, whether that's because you die or you lose capacity to make decisions, your family is not only faced with some legal decisions and some difficult things from their end on that perspective, but also they're dealing emotionally with something that's quite difficult for them. The easier that you can make the process for them, the better for them personally, allowing them time to grieve and process things without having to deal with some additional legal frustrations. In addition to that, having a good estate plan will make things run smoothly from a cost perspective. You're not going to potentially spend time in court getting directions about the way that things should have properly been written, and you may not have the best tax outcome if you don't have things tied up the way that they should be.
That's a very critical point that Paige has identified quite early, is how important it is to think about estate planning early. Lots of people think about tax consequences and will get advice and will structure to suit the best tax outcome, but that might end up having an adverse tax outcome for your estate in the end. So tax planning should go hand in hand with estate planning, and Paige can talk about that more, but it is really important to think about it from the outset, because it may mean if you go later in years and then you decide to think about your estate planning at that point, it might see that really you should have had assets in different structures, which might have stamp duty consequences or other tax implications that you could have avoided from the outset if you had the right advice.
And so I guess on that, thanks, Stacey. How often do people come to see you, Paige, where they think they've got their affairs in order or their future in order, I suppose, or state, and really need to do some more work on that for that smooth transition?
I would say that's probably most people. Most people who have a will in place, but perhaps their asset situation has gotten more complex over the years and they haven't revisited it, and they might have the same general objectives, which is something like everything to my partner and then everything between my kids, but they haven't contemplated the fact that they've now got a discretionary trust with some assets in it, maybe a self-managed super fund that they haven't looked at in a few years. And as a result of some of those surrounding issues, their objectives aren't actually going to be cleanly met anymore. That's pretty common. What we typically like to see is more of a process where we collaborate with their other advisors, because you can sometimes find, as Stacey was alluding to, that different advisors, they'll all have your best interests at heart. Typically what you want in an advisor, but they all won't have the same idea of what your best interests are. You know, your accountant will want the best tax objective, no matter what it takes to get to that tax objective, whereas that may have horrible consequences for your estate and what you may have set up in your will.
And Stacey, when when Paige refers to dealing with other parties or external parties that are holding investments for some of those estates, how does Quanta deal with those, the paperwork trail, I suppose, and what are we presented with at various times that we need to deal with to try and assist in that process?
Probably a thing that I'd like to mention before I touch on that, Tim, is a question that I get quite commonly is how do I deal with my investment? And at the most basic level, the investment just forms part of the estate. So again, something Paige can talk about in more detail, but investors can choose to gift that investment very specifically. So I leave my shares in the Quanta Ann Street fund to my daughter. Very clear as to how you want them to be transitioned. Alternatively, if you just have a whole of estate plan, so for example, my estate goes to my husband, my estate goes to my wife, that forms part of the estate, so it will just go with it. So nothing special needs to be done there. We don't need to be notified in advance, nothing like that. It just gets dealt with under the will. In the unfortunate event that those circumstances arise, and we do have it happen from time to time, investors, the relevant contact of the estate will reach out to us. All we ask for is a copy of the will and the related documents, which Dave will walk the relevant person through the process. We understand it's a challenging time, so we make it as painless as possible. It's a simple transfer form to go to the beneficiary. We process that. There's no fees associated, no transfer fees. And then from that point on, the beneficiary will receive the monthly distributions and will be noted as the owner of that investment.
Okay. That
So
sounds
it's
fairly
very,
simple.
very straightforward. Yeah.
Right. And again, if we can take one step back, Paige, death is part of course, estate planning. But what about the loss of capacity? Can you talk to us a little bit about the importance of that?
Yeah, so it is something that we're seeing a lot more often these days is issues where people have lost capacity before they die. I don't think it was the case that it happened as much as it used to many years ago.
And what do you put that down to?
I think we're just living longer, and so our brain is deteriorating. I'm not a scientist. I couldn't tell you for certain, but I think definitely we've seen an increase in it, and perhaps we understand more what that looks like in people, what a cognitive decline looks like, and how to look out for it. That causes a lot of issues in self-managed super funds. It has control issues in family trusts as well. You'll have control issues where you have somebody who might have previously been in control of an entity that no longer has the ability to make decisions for that entity anymore. It can have issues where you have an attorney making financial decisions for a person who may not be aware of their overall financial strategy or objectives and be able to continue that path forward unless they're doing so in collaboration with an existing advisor. And so we're finding then that we also have advisors who aren't sure about whether they can take instructions from somebody under a power of attorney or whether they can take instructions from a principal who they think maybe has lost capacity to be giving those instructions in relation to investments held with a particular advisor.
Okay. And how does it, the loss of capacity, how is it confirmed or deemed that that's actually now taken place?
Yeah, that's a really difficult question. So capacity is time specific, it's decision specific, it's circumstance specific. So a person can have capacity to make a decision at 10 a.m. On a particular day. They could make maybe a relatively simple financial decision, and by 3 p.m. they may have declined such that they're tired and they no longer have the focus to make that decision anymore. It also depends on the complexity of the decision. So there'll be a different level of capacity required to make a will, as there will be to make a power of attorney, as there would be to transfer a property, or to make a simple decision like paying a bill at a bank. So it's a combination of getting the right medical advice. Usually that's medical advice that's given on the back of a request from a solicitor about the nature of the transaction that you're asking them to participate in. And then a doctor giving a tailored response to that. You know, they're capable of making these sorts of decisions, but probably not these sorts of decisions. And that's where an alternative decision maker will need to get involved.
Got it. In terms of the power of attorney, how important is the value of having a power of attorney?
I think a power of attorney is possibly more critical than even having a will is. At the end of the day, the legislation will provide for what happens to your estate if you die. It might not be the outcome that you wanted, but it will provide for something to happen. In the case that a power of attorney is being used, you have lost capacity, you're a vulnerable person. Somebody's making decisions for you in circumstances where you can't make those decisions for yourself anymore, so you're at risk. So it's really important that the people that you appoint to that role are people that you trust to make those decisions for you. And while there are ways in which a financial administrator or another decision maker can be appointed for you, that involves a QCAT process, typically in Queensland at least, a process where you go to a tribunal and you have to have somebody appointed. And sometimes the tribunal will appoint an alternative decision maker who's the public trustee or somebody that you might not have preferred to be making those decisions for you.
On a percentage basis, how many estates would have a power of attorney already appointed?
Not enough. The power of attorney legislation in its current form is pretty new. I say pretty new, it came in 1998. So there are some people who have powers of attorney from before that time where they only dealt with financial matters. They were under the Conveyancing Act, so they don't have one for personal health decisions. And then there are plenty of people who've just done their will, either that was like a post office will or an online will, and they've never really considered the importance of having a power of attorney document in place.
Yeah, I think with a power of attorney in particular, people will often think of those in conjunction with their will, which is very important, but it's something that could be needed far earlier in your life, because it relates to incapacity. That could be a result of an accident or completely unforeseen circumstances that no one planned for. And it could be that you are incapacitated for quite some time before it reaches the point where your will's being relied on. So, very important from that perspective. And just when Paige was talking about how we now can have attorneys appointed for financial and different types of matters, you can appoint different people for different roles. So often, you'll hear people don't want, the family being either burdened or having the responsibility of making financial decisions, or perhaps because they weren't involved enough in the rest of the estate to understand that. Well, you could appoint a trusted advisor to assist there, and you can have your family to make health decisions. It's not necessarily the same person. So there's a lot of flexibility in what can be done there if it's planned out well in advance. And it all comes back to that prior planning.
Moving on, Paige, to the topic of trust structures. I presume you work closely with a range of trusts, whether that's family or charitable or superannuation. For our viewers at home who hold assets in vehicles like our unit trusts, what are the advantages of using trust to plan for intergenerational wealth?
Trusts are interesting vehicles in that, depending how you set them up, they'll have different consequences when something happens to you or you lose capacity. A trust like a discretionary trust, for example, which is like a family trust that a lot of people hold assets in, the assets in that vehicle, they don't form part of your estate. They're held separately, and the trust will continue to exist long after something happens to you. So it can be a useful way for people to transition wealth to the next generation without it needing to be held in their personal name, which they may choose to do at some point because they've got asset protection concerns or it's good for a tax management reason. And then that vehicle can just be transitioned through a change of control of the trustee or a change of control of a corporate trustee, for example, to the next generation without it becoming relevant to your will. Sometimes people can use those vehicles or benefit from using them if their estate is going to be subject to some kind of risk. So maybe they might have a claim on their estate or some litigation. Because it's not going to be an estate asset, it can be separate and protected from that.
That's quite surprising to me, Paige. So if there is assets in a trust that are outside of the estate, then can you just clarify how that is dealt with?
So in a usual discretionary trust structure, you'll have a couple of ways that you can control your trust. Usually you'll have your trustee. So that might be you as an individual person, or it might more common be you as a director of a corporate trustee and perhaps a shareholder of that corporate trustee. And then you'll have what's often called the role of the appointor or the role of the principal. With a trustee, usually your trust deed, which governs how your trust runs, will talk about what happens if an individual trustee dies or loses capacity. In the case of a corporate trustee, there's a few things that need to happen. If you're the shareholder of that corporate trustee, that's how you have the power to appoint and remove directors, usually of a company, and that's how you change who has control of the corporation. The shares in the corporate trustee, if they belong to you, will form part of your estate, and you can give them to whoever you want to be able to have that power to appoint directors. If you lose capacity, your power of attorney will have the ability to vote on those shares and appoint new directors. If you're the appointer of the trust and you have the power to change who the trustee is, the trustee will usually provide for how succession of control of that role works. Sometimes that will say that it goes to a specific person. More often it will say that it goes to your executor or that your power of attorney can exercise that. Or alternatively, it'll give you the right to pick who can exercise that.
So that just demonstrates how very complex the estate planning process can be, because it's not just a matter of where you want it to go, it's how can it get there. So in those structures Paige was just talking about, that involves, if the entity is already set up, that's reviewing constitutions, trust deeds, any number of documents that are associated with it to see how the change in control can actually be affected. If none of those are set up, then you have the benefit of being able to set it up in the most user-friendly way moving forward.
Paige, how else can estate planning benefit families?
We're finding more these days that people are planning for transitions to occur in advance. So when we're dealing with family businesses or family offices, they are looking to facilitate that transition to the next generation in some ways for their estate before something happens to them. Sometimes that's so that they can foster the next generation to learn about investing, learn how the family business works, start running the family office and sort of find their feet before the key person who's been running it all is no longer available to do so. So sometimes a succession plan can involve implementing structures for that to occur, maybe transitioning certain entities to certain people early, or even sometimes it's things like putting together family constitutions or roadmaps for how the family is going to conduct business and how they plan to transition that wealth over the next 10, 20 years.
Okay, that's probably really important for us, our investors, Stacey, because we do know there's a lot of business owners in amongst our investment group.
Yeah, absolutely. And the family constitution, as a concept, that's becoming more and more popular. And we've certainly seen instances where if done properly, it saves a lot of heartache for the family, because those transitions aren't easy. And it really gives a very clear process for the family for how to move forward.
Paige, for anyone wondering out there, including me, because I haven't got around to doing any estate planning yet, what does the process look like, and how long do you sometimes spend with people when they first come in?
I would say, for the most part, an initial meeting would take about an hour. Any longer than that, and people tend to lose focus or forget the reason they came in the first place. But for the most part, what we're doing in the first meeting with someone is getting an idea of what their family situation looks like, or what their who it is that they want to benefit from their estate, what those people are like in terms of their needs. Are there any special needs of anybody that's there? Does anybody need some additional support? Is there any litigation risk? What are their financial circumstances like? And once we have a picture of what their family looks like and we can identify any associated risks, we'll talk to them about their assets, what they hold in their personal name, what they might hold in related entities or structures. Usually that involves a conversation about superannuation as well, and what they'll have in their super fund and any life insurance. And then once we have that picture and that information, we talk to them about what it is that they want to achieve. And most people will have a general idea of what it is they want their will to say. And it'll be something like, I want everything to go to my spouse, and then I want to benefit my children equally, but I'm really concerned about my son's wife. And I typically find that the question of who's the right person to make decisions is the hardest one for people. Sometimes they'll come in with this complete plan about what asset is going to go to what person and who's getting this and who's getting that. And at the core of it, the hard question for them is, well, can my kids get along in order to make these decisions? Will they make the right decisions? Is that going to be difficult for them? Should I be looking at somebody independent to make those calls for me? Do they need some kind of other support? Is my family trust going to last for another 5 years or another 20 years? And does that inform how I deal with control of that? So it's a lot of those conversations. And often they'll leave that meeting with some things to think about, put some recommendations to them, and then they'll come back and say, well, this is kind of what I want to achieve.
I found it very intriguing, the very creative ways and creative methods that can be put in place to protect assets, and also to make sure that the ultimate beneficiary still receives the intended benefit. So for me, for example, I've got young children. So thinking of how can they enjoy the benefit of an estate, but not do something silly with it in the meantime. And going and seeing someone who specializes in that area, I think I got so much more out of that process, because I got a structure that I'm really happy with, and I feel very comfortable that it is going to protect my children in the way that I hoped it would. And I assumed, that would work very similar if there are challenging relationships within the family and other types of things where you want to be very specific as to how and when assets transition and who receives the ultimate benefit of them.
I think that's why the information gathering process is so important, because it's one thing to have people explain to you, this is what I want to achieve, but you really need to get down into the why they want to achieve that particular thing. Because when you explore the why, you might have 3 other ways that you could achieve that same objective in a way that's easier or more tax effective or ultimately better for them. And that might be a particular type of trust and how you structure that. That might be by restricting some access to capital from a trust until someone's a particular age. It might be restricting your beneficiaries down, so not including spouses, or for some people who are doing their estate planning with a tax planning objective, it might be including spouses. It's about having a real focus on what it is that's important to them, so that whatever you produce at the end of the day is going to achieve that. It's definitely not the case that every will that you draft is going to be the same for every person, and it absolutely shouldn't be.
Well, can we quickly talk about the people that haven't got their estate planning in order?
Mhm.
And without going into great detail, what are some of the issues that fall out of that if it hasn't been updated appropriately or things have changed? Where do you run into issues?
You might have clauses in your will that no longer have any meaning. And if you have clauses in your will that no longer have any meaning, you can often have arguments. So, if, for example, I had a matter where there was a gift of the proceeds of sale of a property, and that property was not in the estate at the time that the person passed away. And so there was quite a significant and expensive argument about, is it a gift of the sale proceeds of that property if it was sold in the estate? Is it a gift of whatever we received from that property when we sold it in 2002? Or is it some other gift of cash that we have to come up with what that is some other way? So simply because the document had been left unupdated since the property was sold, we had this argument. And I think anytime there's uncertainty, there's the risk that families will argue about it.
Will we be surprised at how many family disagreements can occur in this game that you are in?
I don't think most people would be surprised, but certainly I think we hear from people all the time, my kids get along really well, they'll work it out, it doesn't matter if it's not 100% clear between themselves, they'll sort it out. And sometimes that does happen, but for the most part, I think even family members who get on really well get on the best when they are facilitated to have a good relationship. So the less things they have to argue about, the less things they have to come to an agreement on, the better, and the better chance they have that their relationship is going to continue to be a good one.
Okay.
So just don't test it, is my view.
Paige, at Quanta, we typically speak with our investors about medium-term investment horizons of, say, 5 to 10 years. And while some may view this as a long time frame, we consider it the sort of minimum required to actually get a good capital uplift back from when we sell that property. For investors concerned about the possibility of passing away before the asset is sold and their investment plus their capital is returned, how can they better manage or plan for that?
Yeah, so I think as Stacey mentioned before, if you're holding the units in the unit trust in your personal name, it's going to form part of your estate. You don't have to sell all the assets in your estate when it's being administered. You can pass the specific assets to specific people. So sometimes people will use long-term investments. It might be an investment like this. It might be a commercial property that they own personally that's giving them good rental returns, and they'll pass it on to a beneficiary, or they'll put it in a testamentary trust for the ongoing benefit of their children. And that can just happen, as Stacey mentioned before, pass through the will. You complete the requirements on your end, and then that beneficiary will own it moving forward and they will eventually realize it. If you hold your investments in a family trust, like we talked about before, simply about a matter of transferring control when you're not around to deal with it. The only time you might want to be a little bit concerned about it is if you have an asset being held in an entity that has a shorter lifespan. So if you have it held in something like a super fund where you maybe have cashing conditions because you've got cash or assets that have to come out of the fund. But otherwise, it's really not an issue if you have long-term assets that you hold at the time that you pass away or lose capacity.
Thanks, Paige. Stacey, it's very relevant because over 50% of our investment holdings are through people's superannuation funds. So, what are some things they've got to think about when I presume we'll make a transfer for them out of that super fund?
Yeah, so we can still transfer the units as directed under the will, but there may be some other financial or tax implications associated with that, depending on how it's structured. So again, I feel like I'm hounding people about it, but it comes back to the prior planning. So make sure you're getting the good advice early, preferably before any of the investments are made and it's structured properly, and those things will have been taken into account, but also get updated advice as you continue along your investment path.
Thanks, Stacey. Paige, what do you think one key takeaway should be for our investors today?
I think that being properly prepared for what might happen to you is the kindest thing that you can do for the people that care about you.
Very good.
Beautiful. Paige, thanks very much for being with us today. You've been a wealth of knowledge. I've learned a lot, so I really appreciate you coming along. Stacey, thanks as always for being here. And thanks everybody for watching at home. We look forward to bringing you another Quantacast soon.